Mr. President, the most extraordinary feature of the bill before us today is the incongruity between the bill's title and its content. The title, the Protect Women's Health from Corporate Interference Act, is clear and straightforward. It suggests the bill is aimed at the important and worthy goal of protecting women's health. But the text of the bill plainly demonstrates that the bill's true objective is to circumscribe America's religious freedoms, the religious liberties of individual Americans within the narrow confines of the Democratic Party's partisan agenda and the whims of politicians and bureaucrats. While maintaining the appearance of preserving all the current legal protections of religious freedom in America today, this proposal quietly adds to them a subtle yet deeply problematic and inappropriate qualification. The federal government will not prohibit the free exercise of religion until the federal government decides that it wants to do so. Under this bill, your religious liberties stop at the doorstep of the Democratic National Committee. And so I rise today in opposition to this bill because it doesn't do anything to protect women's health, and it does much to undermine the bulwarks of religious liberty enshrined in our Constitution that have made America the most religiously diverse and tolerant nation in human history. Although this proposal is only the latest maneuver attempted by my Democratic colleagues to assert the power to restrict religious freedom in America, it also represents the culmination, at least for now, of their opposition to the Supreme Court's recent ruling in Burwell v. Hobby Lobby. On June 30th of this year, the Supreme Court ruled that the federal government may not force closely held businesses to violate their sincerely held religious beliefs in order to comply with the contraceptive mandate issued by the U.S. Department of Health and Human Services under the Patient Protection and Affordable Care Act. This decision has received a great deal of attention, but it has received this attention for all the wrong reasons. Contrary to what many critics have suggested, the Hobby Lobby decision did not promulgate national health care policy, nor did it render any opinion on the virtues of contraception and religious faith. No, the issue in Hobby Lobby involved not a dispute of competing rights, but a straightforward application of plainly written law. As the Constitution states in Article 3, Section 2, the role of the Supreme Court is to adjudicate legal disputes by hearing cases and controversies that arise when two laws or two parties come into conflict. In Hobby Lobby, the two laws in dispute were the Religious Freedom Restoration Act, passed by an overwhelming bipartisan majority of Congress and signed into law by President Clinton in 1993, and a federal mandate issued by the Department of Health and Human Services, acting under the powers delegated to it by the Affordable Care Act. The Religious Freedom Restoration Act, or RFRA as it's sometimes called, reaffirmed Americans' commitment to the fundamental religious liberty already protected by our Constitution. With RFRA, a Democratic Congress and a Democratic president, in cooperation with Republican minorities in both houses, declared that when the federal government seeks to infringe on Americans' religious liberty, it must clear two thresholds. First, it must show that the law in question serves a compelling state interest. Second, if it does, the law must do so by the least restrictive means possible. Given that the government openly acknowledged that there were a significant number of far less intrusive means to ensure affordable access to the drugs at issue, the Supreme Court rightly ruled that the contraception mandate violated RFRA. However unwarranted, the overheated response to the Hobby Lobby decision among some ideological extremists on the left has led some of my colleagues to introduce a bill that would not simply overturn that modest and narrow decision, but fundamentally rewrite America's social contract as it pertains to matters of personal conscience. Whereas the court's ruling was limited to closely held for-profit companies like Hobby Lobby, this bill would empower the federal government to coerce employers of all faiths and of no faith into violating their deepest personal convictions. It would deny any employer, devout or secular, individual or corporate, for-profit or nonprofit, conscience protection under RFRA against all present and future government mandates. Perhaps most troubling is the warped theory of rights underlying the text of this bill. This theory holds that the American people possess constitutional and legal rights only when acting alone, but not when acting in a group. These rights, along with any duties one may hold as a person of faith, must be forfeited whenever acting in association with others, on penalty of fines to be paid to the federal government. This view of religious liberty might be summarized as an amendment to Matthew chapter 18, verse 20. For where 2 or 3 are gathered together in my name, there is the IRS in the midst of them. This view is extreme. It's out of touch with the Constitution, with common sense, and with America's heroic history of religious tolerance. From our earliest days as a country, one of the sources of our strength as a people, and one of the reasons for our success as a nation, has been our robust understanding of religious liberty. The breadth and depth of that conception has allowed and encouraged people of all faiths and all traditions to live here in friendship and in cooperation with one another. As 2 members of the U.S. Commission of International Religious Freedom put it, quote, respect for the flourishing of people requires respect for their freedom as individuals and together with others in community to address the deepest questions of human existence and meaning. This allows them to lead lives of authenticity and integrity by fulfilling what they conscientiously believe to be their religious and moral duties. It also includes the right to witness to one's beliefs in public as well as in private, and to act while respecting the equal right of others to do the same on one's religiously inspired convictions in carrying out the duties of citizenship, close quote. Expanding as wide as possible the space in which all people can witness their faith alongside one another has for 2 centuries elevated, enriched, and united American society. This robust conception of religious liberty was so essential to American unity that not only did the founding generation reinforce its protection in a Bill of Rights, which many framers actually thought was redundant, but that it was the first freedom articulated in the First Amendment. They understood, as most Americans still do, that the proper role of government is not to define people's happiness, but to protect all individuals' equal rights, to pursue happiness according to their own hopes and values and conscience. Yet, for all its legal and constitutional protections, America's exceptional tradition of religious toleration rests ultimately on the uniquely American principle of equal dignity and respect for all women and all men, not simply as fellow passengers en route to the grave, but as fellow pilgrims in search of their own promised land. The authors of this bill know all of this. They know the American people reject their intolerance of diversity and indifference to the First Amendment. We know their bill cannot become law. Indeed, we know this for a fact because if the regulations they support were actually written in the law, Obamacare itself would never have passed. It was slipped in after the fact by bureaucrats who are not subject to public accountability and never stand for election. This legislation is more than an insult to the people it would target. It is an embarrassment to the party leadership that has embraced it. I still hold fast to the principle and to the freedom it preserves, and thus strongly urge my colleagues to vote against this bill. Thank you, Mr. President.